said, right?
You have said that, yes, Your Honor.
And if that's true, and if Baker v. Nelson has not been overruled by the Supreme Court, they may be ready to overrule it tomorrow, but we can't overrule it, can we?
Well, Your Honor, first of all, this Court has said that the federal equal protection guarantee and the state may be no broader. However, it is in other situations, in other cases, and Judge Kaye has written an article in which she says this, there have been occasions when the Court has certainly done an independent analysis and is not bound by the federal analysis. In addition, there have been subsequent doctrinal developments since Baker v. Nelson had its summary dismissal, and under Supreme Court precedent.
Yeah, but I guess that's what I'm really saying is, I assume you're right, that there are doctrinal developments which make it possible, likely, highly likely, that the Supreme Court would not follow Baker v. Nelson tomorrow. Are we free to say, then, okay, Baker v. Nelson is no longer the law? Or doesn't the Supreme Court have to say that?
I think you're certainly free to say that we're going to construe our state constitution, put Baker v. Nelson aside, say Baker v. Nelson is not controlling precedent, as the Attorney General has said already in an opinion cited in our record, and as has been said by some lower federal courts cited in our briefing as well.
Well, we'd have to say the Equal Protection Clause in New York is broader.
Not necessarily, although not necessarily, because I think Baker v. Nelson cannot be viewed as good law or precedent binding on any court, federal or state, and certainly not on this state.
Well, I get back to Judge Smith's question. I mean, isn't it something different to say that they could change their minds tomorrow, but while that precedent is still out there, it's binding on us to the extent our Equal Protection Clause is coextensive with the federal one?
There have been two federal district court cases in recent years cited in our brief, the Smelt case and In re Candu, that have themselves said that they don't view Baker v. Nelson as binding even on federal courts. So I don't think this court even has to go that far. And then I'd like to turn as well to
So what do you extract as the binding equal protection jurisprudence of the Supreme Court of the United States on this issue?
Well, as the opinion I just read says, the federal law is still an open question under federal law. I think there are important cases, such as the Zablocki case.
So it's just a completely open issue?
There's a lot of guidance from cases in federal law, ranging from Griswold versus Connecticut, the Eisenstadt case, which held that the right to privacy and autonomy in making decisions about whether or not to use contraception was not just a right for married couples, but also a right for the unmarried, and required the court not to define a right in narrow group-based terms.
Do you agree with Justice Scalia that in Lawrence v. Texas basically makes it impossible for the Supreme Court not to hold that gay marriage is permissible?
Well, I certainly do believe that Lawrence v. Texas's teaching and the methodology it follows does mean that any fair application of due process and equal protection doctrine should lead to the conclusion that it is unconstitutional to deprive same-sex couples of access to civil marriage. Yes.
So when they said we're not deciding that and Justice Scalia said don't believe it, you think he was right?
Actually, I believe that what Justice Scalia was right about is that Lawrence is a case that makes very clear how other courts need to address the question of marriage rights for same-sex couples. I think that the Lawrence majority certainly didn't reach the question and was careful to make clear that it wasn't. But I also think Lawrence is important for questions that have come up earlier about whether we're asking the court to define a new right to so-called same-sex marriage, or to simply acknowledge that the right to marry, the well-settled fundamental right to marry, can't be defined so narrowly on group-based terms to exclude an historically excluded group. And in Lawrence, the court overruled Bowers versus Hardwick, which the Lawrence court said Bowers' description of the right at stake and in Bowers' court said it was facetious to claim that there was a right to homosexual sodomy. The Lawrence court said that misapprehended the nature of the right at stake. It was a right to individual autonomy in making decisions about one's private sexual relationships and bonds with another, and that it demeaned the dignity of lesbian and gay people. So
Had Baker relied on,
on Bowers?
Yes.
No, Baker predates Bowers. I'd like to also turn to the discussion about the Turner versus Safley case, because I do believe that Turner is a case that's very on point and important, and I don't think that it's fair to characterize it the way I heard it characterized earlier. I think Turner versus Safley upholding the right of a prison inmate to